Hello, good morning. Welcome to everyone who has joined. Thank you very much for the time that you have allotted to this in your busy days. We're very grateful to you for joining us, and even more thankful for you staying with us through this session. Just to let you know, the webinar is being recorded, and so anyone who would like to watch it subsequently, it's possible for them to do so. If you need to break away for any reason, you'll be able to join again and look at the recording if that's of convenience to you, but we very much like you to stay with us for these presentations. This is the series, the first in a series of presentations on alternative dispute resolution. My name is Philip Sewell. I'm one of the partners in the dispute resolution team in London, and I have panel members with me, Sarah Walker, Gabriella Gilmour, and Lily Manser, who are all solicitors in the London unit. The first of these sessions today is to cover the changing dispute resolution landscape in view of the encouragement given by the courts to parties to explore alternative dispute resolution and the pros and cons of ADR as opposed to court litigation processes to resolve disputes. There will be another session on the 14th of July at this time, again recorded. And I'd encourage everyone who is interested in joining that session to register their interest with reference to the details on the email that will be sent after this session is finished, together with the recording. And subsequent sessions will deal with practical experiences of alternative dispute resolution, as we will be inviting other panelists from counsel's chambers, one in particular being an arbitrator himself and a barrister who has experience of this type of work in her practice, if that's of interest to you as well. I mentioned the panelists. Sarah Walker is a senior associate with experience of arbitration, litigation, other forms of dispute resolution. Lily Manser is an associate in the same area. Gabriella Gilmour is a junior solicitor who has joined us over the last year. Each of the panelists will speak about particular issues in this field. There is a question and answer session that we have allotted in terms of the time given to this. I'd encourage everyone to ask questions that they want to about matters that occur to them in terms of their own practice, matters on their desk or not, as the case may be at the moment. We'll endeavour to deal with those at the end of the presentations. Sarah Walker will explain the functionality aspect of how one asks the question, and we'll endeavour to answer the question once we see it. Last thing to say is, just as a housekeeping point, notes will be circulated at the end of the session together with the email I referred to, so you'll all be getting a copy of the notes for the presentations as we conclude this. So thank you very much again. I'll hand over to Sarah, who will be making the first presentation.
Thank you, Philip. Yes, as Philip mentioned, we encourage and invite you to ask questions of us during this webinar. To do so, we have a Q&A function. Hopefully it's relatively straightforward for everybody. You'll see at the bottom of your screen, there's an icon that says Q&A, and that's the button that you press. You can submit your question via that. The question won't pop up for all to see. It's only us on the panel that will see it. So for any wallflowers out there, don't worry. Your question won't be circulated to all participants, just us. We set aside, as Philip said, about 50 minutes or so at the end of the session, whereby we'll hopefully be able to answer as many of your questions. So please do utilise this function. We very much encourage you to do so. So today's session, particularly my part of today's section, is not about black letter law. You'll be no doubt very glad to hear. The purpose of it, as Philip mentioned, is rather to introduce you to the concept and idea of alternate dispute resolution, or ADR, as you'll hear it referred to in short, and to give you the opportunity to pause and think about how this could should and or indeed does impact your role, and if not your particular role, perhaps those of your colleagues or of your business or wider business dealings. So ADR, what is it as a starting point? Now, apologies to those that know, but I think sometimes it's very helpful just to pause and strip things back to the fundamentals once in a while. So at its most basic, ADR is a mechanism for resolving a dispute outside of the formal court process. So it's an alternative to raising court proceedings whereby you would eventually attend a trial at court in the normal course. It's a private form of dispute resolution as opposed to the more public form that a court offers. And in theory, if the parties so wish, it provides them a much greater amount of control and say in determining how that mechanism works. So by definition, ADR could potentially cover a whole host of things. It could theoretically take on a number of weird and wonderful forms, such as, for example, an arm wrestle or an egg and spoon race, where the rules as established by the parties subject to the dispute state that the winner of the physical act is deemed victorious in the dispute as a whole. Now, thankfully, ADR processes have evolved, and at least I would say in mainstream disputes, and certainly with my mainstream clients, I've not had to deal with any egg and spoon race mechanisms for resolving the dispute. There has over the years been emergence and development of established ADR processes, and as Philip mentioned at the very beginning, my colleague Gabriella will touch on the 5 most commonly recognised and utilised forms of ADR. But whilst my examples are fairly extreme, or I would hope them to be fairly extreme and not a common occurrence, it does highlight one of the key advantages of ADR. And that is, as I briefly mentioned a moment or so ago, it's potentially very flexible in the form, and the parties to the dispute have an ability to map out how the dispute should be addressed should one arise. Whereas the court process is very much regulated and the form is set out by the court rules. In other words, there is a very limited amount of flexibility available to the parties in dispute where a court process is engaged. We will be diving deeper into the pros and cons of those processes in part 2 of the webinar series. Again, Philip touched upon in his introduction, which takes place again next week at this time on the 14th of July. And we encourage you, if you possibly can, to attend that. So now that you know in general terms what ADR is, why is it important that you're aware of it or give thought to it now? Well, no matter what line of work you're in, most of us make decisions, enter into contracts or commercial relations on a fairly regular basis. That's either directly or indirectly. And often, particularly when you're looking at, for example, a consensual transaction, particularly where both parties are working for the same outcome, the last thing on either party's mind is what happens if a dispute arises from this transaction. So a simple example would be a straightforward sale purchase transaction. One party wants to sell an asset for a particular price and another party wants to buy that asset for a particular price. Or, for example, a service agreement. For example, one party wants a wall painted at a reasonable cost and another party wants to provide the service of painting that wall and being reimbursed a reasonable fee for doing so. There, of course, will be key considerations that need to be negotiated, but ultimately the goal for each is the same, and most parties try and work collaboratively together to reach that common goal. Of course, the situation is different in contentious transactions, but the common position that we deal with when we have to look at disputes down the line is consensual transactions. So not surprisingly, then it's only when a dispute arises that a party often says, oh, I wish I had thought about this when we were entering into the transaction. I wish I'd thought about how a dispute would be mapped out. Of course, as a wise person once said, hindsight is a wonderful thing. And interestingly, there have been a various number of research projects that have been undertaken to actually look at human behaviour in situations such as this. For example, in particular, commercial transactions. And this spans substantial ones and smaller scale ones. And the purpose of the research was to analyse a party's appetite and approach to risk or perceived risk when engaged in commercial negotiations. And a number of the subject matters were sophisticated business people and entrepreneurs. So this was not their first rodeo. They were experienced at these type of transactions and what could come of these certain types of transactions down the line, i.e. that disputes could at some point occur. And one of the key findings was that people either don't turn their attention to the mechanism for dealing with subsequent potential disputes that could flow from the transaction because they're experiencing what has been labelled as engagement euphoria, which is a label I quite like. I think it encapsulates the position quite well. And basically, this is where good, positive, and energizing endorphins are being released when closing out an important or key deal or transaction. And what the brain does is focus on getting that deal done or over the line. And to protect scupper in that, people avoid, often subconsciously, issues that could derail that. And the potential for future disputes is deemed one of those topics. It's something that I find quite fascinating. And in addition to the effects of engagement euphoria, often the last thing on anybody's mind often is, what if something goes wrong? So little or no attention is given to that at the time of entering and negotiating the transaction. Part of this can be an active choice, i.e. you don't want to focus on the potential of the parties falling out when trying to get a deal done, which, as I said, often relies on collaboration, or indeed you don't want to send a message to the other party that there's something in this transaction lurking in the background isn't quite right. And you'll be surprised how often subconscious paranoia can play a part in these negotiations. It's avoidance of adopting that, what has been labelled as the glass half empty approach. I suppose a rather extravagant analogy would be that you don't, or at least the majority of people don't, have a divorce lawyer on speed dial or a divorce strategy in place when you're getting married. Now, I wouldn't necessarily advocate doing that. That may have some adverse effects for your personal relationships. But what I would advocate for those that are regularly entering into transactions as part of your role or your business is to give thought as to how you would want a dispute determined if one would arise. It's not the case of adopting a glass half empty approach as traditionally been seen as the issue. It's very much down to risk management and should be presented as that when negotiating any transaction. In other words, it's a value add for both parties, i.e. not a negative, but rather package it as a positive discussion to have mechanisms in place in the hopefully unlikely event that things do go wrong. So one reason that you should give thought to the early stages of it is because it's good risk management, it's good business sense, and we can help you with this. If you feel uncomfortable, if you feel you're not equipped, or if you feel that it's better placed in the hands of the lawyers, which often is the position, then we can help you through that process. Now, ideally, when you want to be thinking about that is when you're entering into the transaction. And as I say, we can advise you on that. But we can also assist in considering any standard stock terms and conditions that you may have, or boilerplate dispute resolution clauses that may be in there that might not be appropriate for your business now as a whole, or might just not be appropriate for the particular transaction that you are involved in at that time. And of course, in the unfortunate event that it does look like a dispute may be brewing, or indeed has perhaps commenced either by way of court process or preliminary stages prior to court process, then we can help navigate you through that. And that leads me on to the other key reason why it's important to give thought to ADR. And that is because it's very much now in the judicial spotlight, with the judiciary actively encouraging that parties consider and explore this as a means to settling a dispute. And in certain circumstances, it's very important to note, parties can be penalised by way of a cost order if they don't do so. And my colleague Lily Manser is going to address that shortly in her section. Now, part of this driver by the judiciary is the fact that the courts, like many an institution at the moment, are under increasing pressure, and there's a focus therefore on promoting the uptake of ADR as the better route over the court process. And indeed, the importance and significance of this was made very clear this time last year when the Civil Justice Council published a report on compulsory alternative dispute resolution. Now, Lily will be addressing this also in her section in more detail, but I thought it'd be helpful just to touch on it and provide a bit of the background. So the background to this report was that in January 2021, the Master of the Rolls, which is a rather grand title for the President of the Civil Division of the Court of Appeal in England and Wales and Head of Civil Justice, asked that the Civil Justice Council, whose primary role is to advise senior committees and members of the courts on civil matters, was to report on the legality and desirability of compulsory ADR. Part of the reason it was asked to do this is there had been a strongly held position supported by case law that compulsory, i.e. mandatory, so not voluntarily adopting an ADR process, but being told that one had to adopt one, had been deemed to be incompatible with Article 6 of the European Human Rights Convention. Now, the report concluded that mandatory ADR is compatible with Article 6 and is therefore lawful. It's been viewed that the conclusions drawn from the report place a useful and extremely powerful tool now in the dispute resolution kit that could provide an opportunity to initiate change in culture, wholesale change in culture in relation to dispute resolution. And the intention is it will benefit all. Indeed, the Master of Rolls, Sir Geoffrey Voss, when the report came out, stated as follows: ADR should no longer be viewed as an alternative, but as an integral part of the dispute resolution process. That process should focus on resolution rather than dispute. This report opens the doors to it and is a significant shift towards earlier resolution. So, as you can see, the judiciary are increasingly and vocally supporting the use of ADR. Now, the CJC report didn't make any detailed proposals, noting that more work is required to determine the types of the claims and the situations in which compulsory ADR would be appropriate. It did rightly recognise that civil disputes span a very, very broad spectrum, and what may be necessarily suitable for one would not be suitable for others. But as I say, the clear message being sent is that parties should give very serious thought to the appropriateness of ADR when faced with a dispute. So again, I drill down to you, if you are involved in any sort of transactional work, entering into any sort of agreements, commercial relationships, please do give this some thought. Indeed, even the judicial marketing, for want of a better word, around ADR has shifted, with the judiciary stating that the A in alternate dispute resolution should be dropped. So it's not seen as another or perhaps a secondary option, but that is equal to, or indeed in certain circumstances, advantageous over the court process. So, conscious of the time, I've largely spoken about ADR with relatively fleeting reference to the court process or litigation, but there is an interplay between the two. And I'll pass over now to my colleague Lily Manser, who will guide you through that and provide you with some further insight into recent developments. Lily.
Thanks very much, Sarah. That was a very interesting start to the session. So I am going to discuss the interplay between ADR and traditional court litigation. And my section is going to cover compulsory ADR with reference to the report Sarah has already touched upon, the cost sanctions for failing to engage in the ADR process, the pre-action protocols and their role in ADR, and I'll give you an example of a piece of legislation that imposes a right to ADR. So kicking off my section with the hot topic of compulsory ADR, which has been hot for some years in litigation, and as to whether or not ADR will become a compulsory step which a party to a dispute must engage in order to resolve a dispute. And as Sarah has already touched upon, the Civil Justice Council published a report in July last year, which followed a consultation as to the legality and desirability of compulsory ADR. So until recently, the approach in relation to ADR has been informed by the Court of Appeal decision in a case called Halsey and NHS. Broadly speaking, the position building on Halsey has been that the parties can be penalised in costs for unreasonably failing to engage in ADR, but cannot be compelled to engage in ADR. However, as we have learned already, that position has been evolving. So turning back to the findings of the report on the question of legality, the report concluded that mandatory ADR is compatible with Article 6 of the Human Rights Convention. And for those of you not familiar with Article 6, this is the legal basis for the right to a fair trial. As to the desirability of compulsory ADR, the report concluded that ADR can be made compulsory subject to a number of factors such as the cost and time burden on the parties, whether the process is particularly suitable in specialist areas of civil justice, the importance of confidence in the ADR provider, whether the parties need access to legal advice in order for ADR to be effective, and their stage in the legal proceedings and whether or not it would be appropriate. So it's very clear that further work is necessary in order to determine the types of claims and situations in which compulsory ADR would be appropriate and most effective for all parties concerned. However, the conclusions of the report, as Sarah has already touched upon, place a very useful and powerful tool in the litigation toolbox. They also provide the opportunity to initiate a change in culture in relation to dispute resolution, which will hopefully go some way to benefiting all parties involved in litigation. Whilst we don't have time to discuss the full detail of the report, you'll probably be pleased to hear, the key findings of the report appear to point to a sea change from the Halsey case. This is evidenced by the first ever court order, which was made in December 2021 by a High Court Master who ordered the parties to meaningfully engage in the mediation process in a genuine attempt to reach settlement. And the court went on to say in the order, the mediation shall be conducted on a without prejudice save as to cost basis, and either party shall be at liberty to make an application relying on the evidence as to the conduct of the parties at the mediation, either with regard to the cost consequences of that conduct or with regards to the court deciding whether or not a party has failed to engage in a mediation process. This later provision was crucial because it provided the powers to lift the lid on a mediation on the matter of cost. And without this power, a reluctant party could simply sit on their hands all day at the mandated mediation. So this is a very important part of the order and leads us nicely on to our next topic of cost sanctions for failing to engage in ADR. So well-advised parties in a dispute will meaningfully engage in ADR, and a failure to do so can lead to adverse cost consequences at a later stage in the proceedings. The courts have the power to make cost awards on an indemnity basis if ADR is not properly engaged, and this can be anywhere between 70% and 80% of the successful party's costs. And this is even the case where a party considers that its counterparty's claim has no merit. So 3 fairly recent High Court judgments act as a reminder that the court will use its power to penalise parties if they unreasonably refuse to engage in ADR, and I'm just going to briefly talk you through them. So the first case is DSN and Blackpool Football Club. In this case, the defendant refused to engage in settlement negotiations and failed properly to respond to a number of formal settlement proposals, which are known as Part 36 offers. Part 36 offers could form a whole session, so I won't go into the nitty-gritty of them, but this just by way of example. When rejecting the Part 36 offer and the claimant's invitation to engage in settlement negotiations, the defendant told the claimant that its refusal was based that it had a very strong defence to the claim. Ultimately, the claimant was successful and the court awarded indemnity costs in favour of the claimant. And when doing so, the court confirmed that no defence, however strong, by itself justifies a failure to engage in any type of alternative dispute resolution. And the court also confirmed that indemnity costs were payable in relation to the defendant's approach to the Part 36 offers. It ordered an interim cost payment in favour of the claimant of £200,000. And this award is all the more remarkable as damages and interest in the claim were just over £20,000. So a very hard lesson learned by the defendant in that case. The second case I want to talk to you about is BXB and Watchtower and the Bible Tract Society of Pennsylvania. This was another case where the defendant failed to engage in ADR because it was confident about its defence in the claim. Again, the court confirmed that this was not a good excuse for refusing to engage in ADR. In this case, at a joint settlement meeting. ADR could have allowed both parties to narrow the issues in dispute, which would have shortened the trial time and therefore the cost burden on the court. The court also criticised the defendant for failing to provide a written explanation for its refusal to participate in ADR. And ultimately, once again, the court awarded an indemnity costs order from the date of the defendant's unreasonable refusal to participate. The third and final case I wanted to talk to you about is Wales Trading as Selective Investment Services and CBRE Management Services. In this case, the claimant proposed a mediation on a number of occasions. The first defendant refused on a number of bases, including, for example, that there were substantial factual issues in dispute at the proposed date for the mediation, provided insufficient time in order to prepare for the mediation. Whilst the first defendant had engaged in ADR by making what is known a without prejudice offer, its refusal to mediate was deemed unreasonable, and the court disallowed 50% of its costs up to the date it made the without prejudice offer and 20% of its costs from that date onward. Interestingly, the second defendant was not penalised for refusing to engage in the mediation, as it had been willing to participate, but not without the participation of the first defendant. The court considered that this was a reasonable ground for refusal. So the lesson that we must take from all of these cases is that win or lose, parties are obliged to conduct litigation collaboratively and to engage constructively in ADR. Parties that unreasonably refuse to engage in ADR should expect to be penalised in costs. So moving on to my next section, which is the pre-action protocols and their role in alternative dispute resolution. So for those of you who are not familiar, the pre-action protocols explain the conduct and set out the steps the court would normally expect the parties to take before commencing proceedings for a particular type of civil litigation claim. So the practice direction on pre-action conduct and protocols highlight the need to actively consider ADR and treat litigation as a last resort. It provides the court with the discretion to take into account any non-compliance when giving directions for case management and for awarding costs, as we have already discussed. The court can give directions to encourage a resolution of a claim. Any unreasonable refusal to engage in settlement discussions, as we have already discussed, will likely be punished through cost awards. And my final topic is just to provide you an example of a type of contract, a piece of legislation rather, which imposes the right to ADR. So there are some contracts and legislation which impose the right to ADR, and an example of this is the Housing Grants, Construction and Regeneration Act, which imposes a right to adjudication in construction contracts. Adjudication is a type of ADR. It's a procedure that provides for the adjudicator's decision to be temporarily binding. That is, it is binding on the parties until the dispute is finally determined. We'll be touching on this later in the session, so I won't go into much more detail on that. But parties frequently include adjudication or arbitration clauses in commercial contracts so that the form to determine the dispute is pre-agreed and anticipated should a dispute arise. And that concludes my section of the session, and I will now hand over to my colleague Gabriella, who will trot us through the different types of ADR.
Thank you very much, Lily. So there are traditionally 5 main types of alternative dispute resolution in the UK, and these are negotiation, mediation, arbitration, adjudication, and conciliation. So I will give a summary of each in turn, starting with negotiation. So this is the most informal and flexible of the ADR processes. It often takes place as without prejudice discussions from the outset and throughout a dispute right up until trial. So this means that the parties' rights are not prejudiced should negotiations not eventually succeed to settlement. The parties retain control of the discussions as it takes place without third-party intervention, so this can save costs and time compared with some of the more formal assisted processes. However, the drawbacks to note with negotiation are that without a neutral third party and the more formal procedures, discussions can often become deadlocked. Furthermore, it is not suitable where the parties involved are not of an even footing. So, for example, in terms of bargaining power or financial standing. So then moving on to mediation. This is where the parties are assisted by a third party, and then all of them identify the issues in dispute and then explore the options for an agreed resolution. The most common style, as there are a few, is facilitative mediation. And this is where the mediator will work to facilitate an agreement between the parties. And this is as opposed to the third party mediator deciding the case on its merits as a judge or arbitrator would in litigation and arbitration. By contrast, another style is evaluative mediation, and this is where the claim or issue is evaluated and the strengths and weaknesses of a particular case are identified specifically. And so mediation then takes place in a private forum and the parties retain control, and this allows for a degree of flexibility and creativity too. And settlement is consensual. So this also has the added advantage of it, meaning that business relations can be retained. An experienced third party can bring a new perspective. So this helps to avoid deadlock, which, as mentioned, is a risk in negotiation. It can be undertaken quickly and relatively cheaply, engaging the relevant stakeholders in the dispute. And though there is no guarantee of settlement, it can trigger the conditions for settlement, so still useful. The main drawback of mediation is that it lacks the tools available to the courts and other ADR procedures. So, for example, compelling the production of evidence or documents. So it would therefore not be suitable where a party suspects another is not acting in good faith. Now to move on to arbitration. So all parties to the dispute must agree to arbitration, and an agreement to arbitrate is usually contractual. So as Sarah and Lily already touched on, it is beneficial to provide for this at the very earliest stage. Arbitration takes place in a private forum with an independent arbitrator, and an award is made in a judicial fashion, and it is final and binding on the parties. There are therefore very limited opportunities to challenge or appeal an award once made. And so during the process, the arbitrator focuses on the issues, whether they be fact or law, and the parties present these issues. The process is tailored to the dispute, meaning that efficient and speedy procedures can be employed if they're agreed between the parties. Parties can choose a tribunal with the expertise relevant to the particular dispute, as well as the number and identity of the arbitrators. So these are seen as particular advantages. And the awards are relatively easy to enforce domestically and also abroad. This is provided that the country is party to a relevant convention. So this is one of the major factors in favour of arbitration over litigation and other dispute resolution processes. Furthermore, in arbitration, claims and defences can be determined summarily, so it can efficiently dispose of meritless claims and issues. So then moving on to adjudication. Adjudication is said to be an interim binding process. So as Lily mentioned, pending agreement of the parties altering its effect or referral to arbitration or litigation for the final determination. An adjudicator usually provides a decision on disputes as they arise. So this is during the course of a contract. It is a quick, just 28-day procedure. So this may not be suitable for more legally or factually complex disputes, or those where there are several issues that need full and complete investigation. The process aims to limit disruption and cash flow problems, and a dispute really may be referred at any time. So this allows for resolution without jeopardizing ongoing contracts, ongoing relations, and such like. Furthermore, the preparation costs are restricted by the tight timetable. So that's definitely a benefit as well. And furthermore, each party bears its own costs. Parties can choose who adjudicates the dispute. So this is very much unlike in court. So you may even choose a non-lawyer with particular expertise in the very subject matter, which again is a huge advantage. Parties are also generally able to choose which adjudication procedure will apply, and this can allow for more flexibility than the civil procedure rules, as touched upon. And as some of you may well know, this has particular use in the construction industry. So finally, on to our fifth process, that's conciliation. Conciliation is a non-binding process with third-party intervention and is therefore quite similar to mediation. However, usually the third party will actively assist the parties to settle the dispute, for example, by making active suggestions regarding the different settlement options. Often parties welcome the more proactive approach of the third party in steering the parties towards achieving a settlement. So this is really the real distinction between this and mediation. And you'll find it is quite common in the employment arena as facilitated settlement discussions. It's also the term used in Europe to describe the function performed by judges when they hold settlement conferences with the parties in an attempt to assist them to reach a settlement of their dispute. So that ends the summary of the 5 procedures. If you have not already, please do post your questions in the box below, and we shall now begin the Q&A. Thank you.
Well, thank you very much to all speakers. I hope and trust that's been of use and interest to all of you. Certainly was to me, reminded me of a number of things that had slipped my mind initially, but now back in the forefront of my mind. If anyone has a question that they want to pose, please send it through. We have a couple of questions already that Sarah will read out, and we'll endeavour to debate them to the extent that we have time left to be able to do so. Thank you.
Thanks, Philip. So the first one that's come through, which is a good one, it's quite a wide question, but I like it. And they're asking what our view is on how quickly, efficiently and cost effectively arbitration works as a process compared to the court process or litigation. So I'll throw that open to the panel. I've got a few views myself, but I don't know, Philip, you want to give your tuppence worth?
Yeah, my initial response to that is it is a wide question, raising a number of different thoughts. Arbitration is a private process agreed to between parties who are protagonists to a dispute, who want it to remain private and confidential. It's efficient to the extent that both parties engage in the process, what's required by it, select an arbitrator and follow the arbitrator's rulings and ultimate award. Sometimes arbitrators can step outside of the remit or reference to arbitration has been taken and can render the process null and void by reason of the fact they have done so. Very limited occasions when that occurs. They try a matter they're not asked to try, or they don't have the experience of the subject matter of the dispute that gives rise to a challenge. And that's where the courts become involved in supporting and intervening in the arbitration process. We have talked today about ADR as a concept, almost hermetically sealed away from court processes. I think it's fair to say that where there is a failure or where a dispute requires intervention of the court, for example, to challenge an arbitration award or to ensure it's enforced, then one always has to bear in mind the court power and the parties' obligations to ensure that the power of the court is utilised to resolve the dispute. No good having an award simply is a piece of paper with writing on it with regard to who's to pay whom what. You need to get that enforced. No point otherwise in undertaking the process, and that's where the court may come into things. So mindful of costs, mindful also of the fact that matters are required to be private in the arbitration context. there's still a need sometimes to involve the court in the examples I've just given.
Yeah, no, very good points. And sort of as I saw the question when it came in, I was thinking about what my answer would be, and it's probably one that is going to receive a collective groan, because it's possibly an answer that many of you will get from a lawyer. To their unsatisfaction is it depends, really, and it does depend. I think the ability to conduct ADR, particularly arbitration, as opposed to a litigation process, the ability to do it quicker, more efficiently, and cost effectively is there, but it all depends in terms of how that arbitration is governed. So you can get ad hoc arbitrations, which is loosely, if it's in England and Wales, will be governed by the Arbitration Act. You can get institutional rules that the parties have agreed that they'll sign up to at the beginning. And it really just depends how that timetable's been set out. So it can on many occasions be much more effective in respect of a time element. It can on occasion be more effective on a cost element, albeit I would say that when ADR processes such as arbitration came out, one of the very big pros promoted was cost savings, and there is an element to that, in that the cost savings can be made, but they're not necessarily cheaper than litigation. I think you have to bear that in mind. It very much depends the type of dispute and the engagement of both parties in that dispute. So it can be quicker, it can be more cost effective, but not necessarily would be my answer. I don't know if Gabrielle or Lily have anything they want to add to that particular cue. Nope, I think I stunned them into silence. Good stuff. Okay, so another question that came in, and this touches on a point that Lily raised in respect of the Housing Grants Construction and Regeneration Act, and the question, and this is where there is an element of compulsory ADR, as it were, in terms of the adjudication process. And the question was, do you think there are any drawbacks to the adjudication process under that particular statute? I don't know if Lily has any thoughts on that, or I'll just open it up to the panel as well. Not an abundance of thought on that, but I'll give my top and thought on that. I think when thinking about the general advantages and disadvantages of adjudication, I think the key advantage really, and the purpose of it really being introduced in the types of disputes that it's introduced in, which is the construction predominantly disputes, particularly under the statute, the practicalities of it really was to keep cash flow running. That's why there was interim decisions, not necessarily finally binding decisions, but interim decisions that could be relied upon, and that was to help with the cash flow of construction projects. So the practical reasons for introducing that I completely understand and get from a business perspective. In terms of sort of the more legal perspective of it, there are disadvantages to it in respect of that it is interim, it's not finally binding. So you may be the party who's on the end of a decision that will cost you perhaps quite significantly over a very short period of time. And I think last time I was involved in one of these, I think the decision period really, the intention is to span about 28 days from raising of the adjudication, the interim adjudication decision. So it could be it could be, you could get a very adverse interim ruling that could adversely affect your financial position, that ultimately is not the ruling that is determined after a full consideration of the dispute. Obviously, in terms of these, it is very fast track for the purpose of the cash flow, the reasons of the practicality of introducing these. There's not evidence isn't considered in the same degree or anywhere near the same degree as certain other types of ADR, obviously litigation. Often there is no testing of evidence or assertions. So I think it's great for its practical reasons as to why it was there, but there are a number of disadvantages there in terms of what could be perceived to be the fairness of the decision making and ultimate determination of what is actually at dispute. And I don't know if anybody else has any thoughts on that.
No, I think you make a good point about cash flow and keeping relations going and ensuring that matters are resolved quickly and efficiently. But they can be a bit arbitrary in my experience. They can be ad hoc and sometimes quite capricious, I think would be the way to put it. Not lending itself very well as a process to anything that requires live evidence, anything that can be determined on paper by way of submission or with reference to documentation, adjudication, good for that, but a more thorough and detailed process involving examination of witnesses, my experience, no, not at all. I think we have a slight problem with people not being able to unmute themselves. So if you can bear with us with that, so my apologies for that being a technical issue that we're struggling with. I think there's another question that has been posed in relation to expert determination that Gabriella, I think you wanted to answer.
Yep, I can. Can you hear me? Yeah, I'm very happy to answer that. I should have mentioned there are two sort of other quite common procedures that I should have touched on that you might have heard of. And they are indeed expert determination and early neutral evaluation. So expert determination is a private and confidential process, aside obviously from the involvement of the expert. There are limited rules of process and procedure, meaning that the expert's approach can be flexible and inquisitorial. It's not usually appropriate for resolving matters involving extensive factual or purely legal disputes, and it results in an imposed outcome outside of the party's control. It's less costly than arbitration or litigation and is likely to be significantly speedier than arbitration or litigation, although a lack of established procedure and law or the ability to be referred to the court for a preliminary ruling means that it could result in delay. But it does produce a contractually binding decision with limited routes of appeal. But then on the other hand, decisions can't generally be enforced without further court action or arbitration. And obviously, it's the expert determining the dispute, which is an advantage as opposed to in court where you don't have any choice with who is hearing the dispute. And then early neutral evaluation, similarly, it's confidential aside from the involvement of the neutral third party, although they will obviously be subject to a duty of confidentiality. Similarly, it's not suitable for cases involving disputes of fact where witness evidence is needed and the parties lose control of the outcome of the neutral third party's evaluation. And it doesn't result in an imposed settlement, but it's definitely useful in cases where negotiations have become deadlocked.
Thank you very much. A slight nuance to that question and follow-up to it we've received is, are we able to advise the position in Scotland? Now, personally, that stumped me because I'm not qualified to advise on Scots law issues. Neither is Lily. Sarah has a Scots qualification as well as qualification to practice in England and Wales. So if we can provide an answer, it would have to be from Sarah, but it may well be that we have to give a response in writing to that question, which we're very happy to do, but that's stumped us on this panel, save for what Sarah might have to say about it.
Yeah, no, I can't hide the accent, unfortunately, so I cannot pretend not to be aware of the law in the jurisdiction. As Philip said, I'm dual qualified, although I predominantly now do English litigation. ADR does exist in Scotland. It is far less utilised. The same general types of ADR process exist. I'd say mediation is probably the most popular, if I can say there is a popular type of ADR in Scotland. As I say, it's much less utilised in Scotland. The Scottish courts aren't certainly as positive, I think I could say, or they haven't until relatively times been as supportive of ADR in terms of seeing its benefits. I think the tide is starting to change, however, and there is a move towards seeing the benefits of ADR. What I can say from a relatively high level point of view, albeit as Philip says, we can follow up in more detail, is it does exist. It is less I don't know if popular is the fair thing to say. I think it's less promoted and just less utilised, but the tide is turning. And I think there will be going forward, particularly given there is a number of pressures on the Scottish courts as there are on the English courts, that this will become more to the forefront. Part of the reason for the popularity of arbitration, for instance, in England, is that London is seen as one of the largest central hubs for arbitration. And I don't think that will ever change. Maybe perhaps Edinburgh or Glasgow, which obviously have are considerable financial cities, they may try and build upon their presence in terms of providing those types of services and becoming more of a popular jurisdiction to do those things in. But as matters currently stand, it exists, but it certainly is not. It's not as utilised as in England and Wales, I would say.
I'm taking the topic of the discussion slightly away from that particular subject matter, but just to give you a further thought on this, the Scottish courts tend to look to London, the Royal Courts of Justice, for leads on how to deal with matters, because of the fact that by way of volume and complexity, as a real generalization, sometimes it can be said that the Court of Session in Scotland, for example, does not have the ability to create law in the same way that English judges do, simply because of the number of disputes that they're required to resolve that give rise to issues of law. In my practice in recent years, I've had two instances where Scottish judges have looked to the solicitors acting in the dispute for guidance on how to deal with, for example, class actions. What orders need to be made by the Scottish court in relation to how a class action is to be conducted before the Court of Session. An expert view will be given by an English practitioner as to how that should be undertaken, and the Scottish judge therefore has reference to that in terms of the ruling he or she makes in respect of an action of that nature. Secondly, in relation to third-party disclosure orders, I had an occasion where a Scottish judge wanting to know what the practice was in England with regard to what orders would be made by an English judge against a third party to litigation for production of documents relevant to a dispute between two other parties. That required the expert view of a retired judge in England to be obtained, advice given on case law, such as Black and Sumitomo's, I remember it's coming back to me, and again, the Scottish judge determining with reference to what the practice is in England with regard to what orders should be made for third-party disclosure. To conclude all of that with those examples, my view would be that with respect to what happens in Scotland, judges are likely to follow what happens in England and indeed in other jurisdictions with regard to developing a body of law in Scotland on this particular subject, so far as that particular matter is concerned. Have we got any more questions, or have we run out of time? I think we're almost at the end of this session, aren't we? Have we got time to do one more question, you think?
I think we could maybe squeeze one final one in, and actually
Okay.
it touches on something you mentioned earlier, Philip, so it might be a good one to finish off on. And it's in relation to we've been asked what our view is of the process for enforcement of arbitral awards in terms of timings and costs. And I think you touched on the enforcement of arbitral awards when you were answering another question. So it's whether, do you have anything additional to say to that? I suppose the only thing I have to say, and it's not so much the timing or the cost, it's the ease in many a sense is probably the best word to use, of enforcement of arbitral awards where there's a cross-border element that I would probably highlight, and that's become particularly significant after Brexit. Pre-Brexit, there wasn't such an issue in terms of the enforcement of English judgments that are determined through the courts, because we had a number of conventions, or where reciprocity, if I can say it, put my teeth in, was present. Now there's a bit of a dark cloud over the ability to enforce certain judgments now post Brexit, and that hasn't been entirely ironed out, or probably even close to being ironed out yet. Whereas arbitral awards, because the majority of those are subject to the New York Convention, which has a considerable number of states signed up to it, that doesn't become an issue in terms of enforcement. So my answer to that is, when you compare it to potential issues now in terms of enforcing English judgments where there's a cross-border element, then certainly there is less of a concern now, because of the ease with which you can do that, because of the reciprocity present because of the New York Convention. Whereas with court judgments, there is a question mark there. So I don't know if you have any sort of final thoughts on that, Philip, or others in the panel.
No, I think that encompasses really the way I was thinking about how to answer that question. So thank you very much. I think that's good. Any other ideas or thoughts that anyone has on that particular matter? No. Okay. I think we have just about reached the end of our allotted time. Thank you very much for joining. And as I said at the outset, thank you even more for staying with us, looking at the number of participants. We have another session on the 14th of July, as Sarah said. So we'll be in communication with you about that, together with the notes for this and ability to access our recording. And we look forward to seeing you again. Thank you very much.
Thank you.
Thank you.